Have you ever gone to the wrong court, and I mean that literally, to settle a dispute?
What do you mean the wrong court?
Imagine you file in one courthouse, go through the whole process, come back, and the judge says, "Actually, we never held power here. Start over somewhere else."
After all that, that's a nightmare.
That's exactly what Adrian Jules told the federal court in Manhattan, the court he originally chose. That's what we're talking about today in Jules versus Andre Balazs Properties.
And the Supreme Court just agreed to settle it. For everyone who ever signed an arbitration agreement and might need a court to enforce or challenge the result, this one matters.
Welcome back to the High Court Report. Today, when a federal court sends a dispute to private arbitration and arbitration ends, does that court keep power to act on the result, or does everyone start over in a new court? Before dialing in, here's your quick reminder to please follow, rate, subscribe, share, and review the podcast on Apple, Spotify, YouTube, anywhere you podcast. Follow on LinkedIn to get a nearly daily rundown, and follow on YouTube to see shorts. Just search the High Court Report.
And if this case has you confused about where to file your next arbitration grievance, reach out on LinkedIn at the High Court Report. All right, here's what you need to know. Oral arguments take place on Monday, March 30th.
Here's the official question the Supreme Court must answer: whether a federal court that stays a case pending arbitration meaning private dispute resolution outside of court, maintains jurisdiction over a post-arbitration application to confirm or vacate an arbitration award, where jurisdiction would otherwise be lacking.
Help me break down that legalese.
Sure, you file a federal lawsuit, the court holds power over your case, but your contract has an arbitration clause, so the court says, pause, go to arbitration. You do. Arbitration ends. Now someone wants the court to rubber stamp the result or throw it out. Does the court still hold that power, or do the parties file a brand new case somewhere else? And somewhere else means state court. The Federal Arbitration Act, the federal law governing arbitration, never automatically creates federal court jurisdiction. When arbitration ends, you need an independent basis for the federal court to act. That means parties from different states with more than $75,000 at stake, or a genuine federal legal question on the face of the confirm-or-vacate application.
And in this case, neither exists. Both parties are California citizens, no diversity. The application raises no independent federal question. Under a strict reading, the federal court arguably never held power to act at all.
Which leads us to the story of how this got here. This story involves a hotel, a pandemic layoff, and some of the worst arbitration behavior a private arbitrator said he ever encountered.
How bad?
The arbitrator handled hundreds of cases in his career and called this the worst conduct he ever saw.
Adrian Jules worked as a security guard at the Chateau Marmont, the legendary hotel in West Hollywood, California, partly owned by Andre Balazs. In March 2020, management laid Jules off during COVID-19. More than 6 months later, Jules filed an EEOC discrimination charge. The Equal Employment Opportunity Commission enforces federal employment discrimination law, and received a right to sue letter 1 week later. Despite holding a binding arbitration agreement covering all his employment claims, Jules filed a federal lawsuit in December 2020 in the Southern District of New York, targeting the Balazs corporate affiliates instead of Chateau Marmont, his actual employer. The respondents say Jules structured it that way to avoid his arbitration agreement.
The court stayed the lawsuit under Section 3 of the Federal Arbitration Act, the provision requiring courts to pause cases containing arbitrable claims, and sent Jules to private arbitration with Jams in Los Angeles.
Jules initiated arbitration in August 2021. Hearing date, December 5, 2022. 1 week before the hearing, Jules's lawyer claimed Jules couldn't participate for medical reasons. The arbitrator found the evidence insufficient. Jules then failed to appear at a special hearing to prove his condition. At the actual hearing, Jules appeared on Zoom, microphone muted, then disconnected. His attorney, Thomas Farinella, refused to present any evidence, witnesses, or even an opening statement. The arbitrator concluded this was deliberate, a manufactured reason to challenge any adverse award.
On January 17, 2023, the arbitrator ruled $0 for Jules on every claim. He sanctioned Jules $11,416.50 and Farinella $23,026.50, a combined $34,443.
Jules then returned to federal court, opposed confirmation, and raised a jurisdictional challenge for the first time. The district court confirmed the award. The Second Circuit affirmed. Now it's at the Supreme Court.
And here's why. 7 federal appeals courts allow federal courts to retain jurisdiction in this setting. Only the Fourth Circuit demands a new independent jurisdictional basis after arbitration concludes. That disagreement among the appeals courts, called a circuit split, gets the Supreme Court's attention every time.
Let's break down the arguments. Jules, who originally filed in federal court himself, argues against jurisdiction. His main argument, statutory text. Jules points to Section 8 of the Federal Arbitration Act, the maritime provision covering shipping disputes. Section 8 expressly tells courts to retain jurisdiction to enter its decree upon the award. That language appears nowhere in Sections 9 or 10, which govern confirm-or-vacate applications in ordinary civil cases.
Congress knew how to write retain jurisdiction. It chose not to in the sections that apply here. Jules draws from the Supreme Court's 2022 decision in Badgerow v. Walters, which held federal courts cannot use a look-through method to establish jurisdiction over Section 9 and 10 applications. The court in Badgerow said Congress included look-through language in Section 4, but omitted it from Sections 9 and 10, and that omission controlled. Jules applies the same logic. Omit retain jurisdiction from Sections 9 and 10, and the anchor theory fails.
What's the anchor theory?
The idea that a previously filed federal lawsuit anchors the court's power over later confirm or vacate proceedings, even when those applications lack any independent federal hook. Jules says no anchor exists in the text. Adopting one would reward parties who file pointless federal lawsuits just to lock in a federal forum, the exact waste the FAA tried to prevent.
The Balazs respondents take a completely different approach. Their argument, Jules asked the wrong question. The respondents say the real question asks whether the FAA strips away jurisdiction Congress already granted in Title 28, the General Federal Jurisdictional Statute. It doesn't. Their hook, the Supplemental Jurisdiction Statute, 28 U.S.C. Section 1367, enacted by Congress in 1990, which grants courts supplemental jurisdiction over all related claims forming part of the same case or controversy once original jurisdiction attaches.
The post-arbitration motions don't just relate to the original dispute, they resolve it. The arbitration award settles the employment claims. Confirming that award finalizes the case. That's not a new lawsuit, that's the original case reaching its conclusion.
Balazs also flipped Badgerow. Badgerow addressed only a brand new freestanding post-arbitration lawsuit where no prior federal case ever existed. Here, Jules filed in federal court first. The court stayed the case, and the parties returned to that same pending action. Cortez Bird Chips versus Bill Harbert Construction, a 2000 Supreme Court case on FAA venue, stated outright, the court with the power to stay the action under Section 3 has the further power to confirm any ensuing arbitration award.
And Balazs flags a practical chaos scenario. Congress forbids immediate appeals of orders compelling arbitration. So under Jules's theory, a losing party would simultaneously run a federal appeal of the pre-arbitration order while litigating post-arbitration challenges in state court. 2 tracks, 2 courts, each threatening to moot the other.
So what does this actually mean for real people?
If Jules wins, anyone who took a federal lawsuit to arbitration and won now faces a detour. Refile in state court to confirm the award, pay a new filing fee, reserve defendants who may dodge service, and educate a brand new court from scratch. Aggressive defendants will exploit every procedural roadblock on the way.
If Balazs win, The rule stays what it already looks like in 7 circuits. Parties return to the federal court that handled the original case, one proceeding, one appeal. The court that started it finishes it. Businesses that rely on arbitration agreements, which show up in virtually every employment and consumer contract, get certainty about where enforcement happens. So those are the stakes.
Let's turn to oral arguments. Oral arguments take place on Monday, March 30th. Listen to them here at the High Court Report. Listen for the justices to press Jules on Section 1367. His brief focuses almost entirely on the FAA's text, but never fully explains why the FAA's silence on jurisdiction retention also silences Title 28's Supplemental Jurisdiction Grant, which Congress enacted separately and never carved out for FAA cases.
Watch for questions about where jurisdiction lapses under Jules' theory. The original employment claims stay pending until the court enters final judgment. Does the court hold power to enter that judgment, but somehow lack power to decide the post-arbitration motion resolving those same claims? Jules never answers that. The fault line on the court likely runs between textualism and practical coherence. Section 8's retained jurisdiction language carries real force with textualist justices. But requiring parties to run 2 simultaneous court tracks may give even textualists pause.
Bottom line time. Why does this case matter?
Tens of millions of Americans hold employment contracts, consumer agreements, and financial products with arbitration clauses. This case determines whether, when arbitration ends, they land in the federal court that already knows the dispute or start over somewhere new.
That's it for today's episode. Final reminder to please follow, rate, subscribe, share, and review the podcast on Apple, Spotify, YouTube, anywhere you podcast. Follow on LinkedIn for a nearly daily rundown and follow on YouTube to see shorts. Just search the High Court Report. Talk to you soon.